Thank you very much for joining us this morning for our third episode in our Cover Talk series. If you haven't joined us before, this is 30 minutes where you'll get 15 minutes of talking from us about some key insurance terms and principles, and then you'll get an opportunity to ask questions that we'll answer at the end. A couple of housekeeping issues, but before we get to that point, for those of you who don't know me, I'm Burnett. I'm a Principal Associate in Mills & Reeves National Insurance Practice, and I'm joined today by my co-speaker, Emma Harrison, who's also Principal Associate. Emma's based in Manchester, and I work between our Manchester and Leeds offices. And our practices are fairly similar in that we both deal with professional negligence and D&O claims, and we also give advice on coverage disputes and issues. What are we talking about today? We're going to be talking about warranties, conditions, well, their conditions and conditions precedent. So these are the core terms that insurers rely on to restrict and limit their liability. We're going to look at what they are, how to spot them, and what happens if they're breached. We're going to take a very brief glance at what the law was like under the Reinsurance Act, and we're also then going to just take an updated view, looking at the impact of the Insurance Act and what the current position is today. A couple of housekeeping issues just to start with. This session is being recorded. As I said, you are allowed to ask us questions. Please do so in the Q&A box at the bottom of your screen, and those questions will be fed through to us at the end, and we'll do our best to give you the answers that you want. And finally, there is a poll. This will happen once during the session. It'll be towards the end of my section, and I'll give you 10 seconds to answer a question. There are only two options, and then I'll share the results, and we'll talk about those results following the poll. So at this point, I'm going to hand over to Emma Harrison, and she's going to talk to you about warranties.
Okay, so warranties. First of all, what is a warranty? In simple terms, it's a promise by a policyholder that a statement of fact is and will remain accurate, or that they'll undertake some specified obligation. They're much more common in certain types of policies. So, for example, buildings insurance policies will often contain various warranties relating to security and fire safety, and usually an obligation to keep the property in a good state of repair. They're less common in other areas, including most PI policies, FI and D&O policies, but they do still come up. So under the old law, under the Marine Insurance Act, the essential characteristics of a warranty were, first of all, it had to be a written term of the contract. So contrast that to representations, which are generally statements made outside of the written contract. It didn't necessarily need to be material to the risk. So you could, for example, have a flood risk policy that contained a burglar alarm warranty in it. They had to be strictly complied with, which is an important point that we'll focus on in today's talk. And any breach of the warranty would automatically and permanently discharge the insurer from all liability under the policy from the date of the breach, regardless of whether it was related to the loss in question or whether the breach had been remedied by the time the loss occurred. So the principle of strict compliance meant that until relatively recently, warranties were one of the most draconian tools that insurers had to avoid liability. Most of you will be familiar with the case of Genesis Housing. The facts of that case are more detailed than we've got time to go into in any detail today. But in short, that case involved a premier guarantee policy relating to a building project. And the proposal form contained the wrong name of the project builder. So on the proposal form, the builder was named as Time and Tide Construction Limited, whereas the correct name should have been Time and Tide Bedford Limited. So a seemingly simple and innocent error to make. But the court, and this went all the way to the Court of Appeal, found that because the proposal form contained a basis of contract clause, and the wording of that clause is on the screen here, that essentially elevated every statement or representation made in the proposal form into the status of a warranty, which meant that the wrong information about the name of the builder on the proposal form amounted to a breach of warranty, which in turn allowed the syndicate to avoid liability completely. So in effect, it was as if the policy had never existed at all. So what's the position now? How has this changed? Well, under the Insurance Act, the law relating to warranties has changed significantly. So first of all, and very importantly, Section 9 of the Act has abolished basis of contract clauses completely. They attracted a lot of criticism from the court, so it's not surprising that they were abolished completely. Now in practice, this means that the burden has been put back on underwriters to really think carefully about the sorts of things that they absolutely don't want to cover and to make sure that they include specific warranties or conditions precedent in the policy wording itself, or perhaps think about specific exclusion clauses. Section 10 of the Act also means that any warranties that are included in the policy are now suspensive. So whereas before, a breach of a warranty would have meant that the policy was void permanently and automatically, now under Section 10, an insurer can only rely on a breach unless and until it's been remedied. That is, assuming a remedy is possible. Take a basic example. If a policy contains a premium payment warranty that requires, say, payment by the 1st of June, if payment isn't made by that date, then under the old law, the policy would have been void. But under Section 10, if payment's made late, so say on the 15th of June, that means the breach is remedied and the insurer goes back on cover from that date. So any losses that occur after the 15th of June do fall for cover again, subject of course to any other policy terms and conditions. It's also worth noting that the Insurance Act repeats the position under the old law, that a breach of warranty is still excused in certain circumstances, including if compliance is no longer possible due to a change of circumstances, or if there's been a change of law that renders compliance unlawful, or if the insurer waives the breach. In practice, waiver is by far the most common and important probably, but we don't have time to talk about that today. It's probably a topic in its own right. So I'll hand over to Liam to talk about conditions and conditions precedent.
Thanks, Emma. Okay, so what are they? Let's take bare conditions first. These are not core or fundamental terms of the contract. They're more of a collateral promise that something must or should not be done by the policyholder, but where the policyholder's right to an indemnity does not depend on the promise being fulfilled. So take the case of Stoneman and Ocean Railway, for example, a term which said, in the case of fatal accident, notice must be given to the company within 7 days. This was read to be a bare condition, so breach did not give the insurer a defence to payment of the claim. Instead, breach of a bare condition will give rise to two outcomes. First, the insurer will have a claim for breach of contract, so a claim for damages against the policyholder, and the extent of those damages will equate to the extra expense that the insurer has had to incur as a result of the breach, which will then have to be reimbursed by the policyholder. In insurance circles, this is commonly referred to as prejudice, and the burden is on the insurer to demonstrate the extent of any prejudice caused, unless the contract says otherwise. Conditions precedent are very different. These are terms that must be complied with, and they commonly take one of two forms. Either in the form of a prerequisite to the insurer's liability, or as a precondition to payment. There is a prerequisite to the insurer's liability. The right to an indemnity doesn't exist until the term is complied with. However, if it's a precondition to payment, the right to indemnity exists, but it can be lost if the condition is not fulfilled. So as a result of this, under the Marine Insurance Act, the remedies for an insurer for breach of a condition precedent were either that the insurer would have a complete defence to payment of the claim, or even worse, for the policyholder, the insurer might be discharged absolutely from any liability in the policy. And unlike with bare conditions, the insurer wouldn't be required to demonstrate that they'd suffered any prejudice as a result of the breach. The breach was sufficient in itself. But it was this kind of draconian measure that the Insurance Act was introduced to moderate. So how do we spot conditions precedent? Well, it's not always easy, because the policy doesn't always say expressly that a term is a condition precedent. So it's often necessary to look at the precise wording of a particular term. Now take the term at the bottom of the slide here. No claim shall be payable unless the terms of this condition shall have been complied with. Now this term is clearly a precondition to payment. So the cover exists, but the failure to perform the term might give insurers a defence to paying the claim. Now, modern drafting techniques have brought improved clarity, and we often see conditions precedent and sometimes warranties arise in two ways. First, either the policy will contain a central statement which says that all conditions within the policy shall have the effect and status of the condition precedent, or alternatively, that no terms shall have that status. In another form, we usually see conditions precedent or particular clauses, contain an express statement which say the term is intended to have the effect of a CP. But any ambiguity or lack of clarity will be construed against the insurer, and contra proferentum principles will apply. And what's the position under the current law? Section 11 of the Insurance Act is really important. I'm going to talk about Section 11.1, and this determines whether or not the section is triggered. I'm then going to hand over to Emma, and she's going to talk about the application. When it comes to Section 11, here we're talking about all risk mitigation terms. So that might be CPs, bare conditions, or warranties. In short, it's any term where compliance would tend to reduce the risk of a loss of a particular kind, or loss at a particular location, or loss at a particular time. Now, such terms exist to limit the insurer's liability, but usually they would also, where complied with, tend to reduce the risk of a particular peril occurring. Section 11, let's just go through this example to illustrate when Section 11.1 might be caught. So a clause which says a policyholder must install and always set out of hours alarm at the warehouse, clearly compliance with this term would tend to reduce loss of a particular kind, so loss incurred by burglary or theft, loss at a particular place, i.e. at the warehouse, and loss at a particular time, i.e. out of office hours. Section 11.1 does not apply to terms which define the risk as a whole. Okay, so what does that mean? Not always easy. The Law Commission did give some guidance. So the examples that you see on this slide are terms that, in the Law Commission's view, define the risk as a whole. It's often thought that exclusions will not be caught by Section 11 because, by their very nature, they identify what the policy doesn't cover, so that goes to the risk as a whole, but also where the policyholder can't typically comply with the terms of an exclusion. So the losses or the test envisaged in Section 11 isn't really engaged. However, there is some scope for confusion here because there may be terms which both define the risk as a whole, but are also caught by the Section 11.1 test. I'm going to ask a question at the end, so you're going to get a poll come up on your screen, but it's based on this set of facts. So a business purchases bespoke insurance against theft for a warehouse that stores high-value goods. The warehouse is situated in an area with a notoriously high crime rate, and the policy contains a warranty or a condition precedent that the warehouse must be watched by at least 2 security guards out of normal business hours. There's a break-in and £500,000 worth of stock is stolen, and then the theft occurs at night when only 1 security guard is on site. So I'm going to ask a question. I can find the poll button. Poll button is not appearing. Is Section 11.1 engaged? I'll give you 10 seconds to answer this question. Yes or no? Okay, now we can see the answers, please. Yes, 79%, no, 21%. Well, look, it's really interesting because clearly this is a bespoke policy. It's just taken out to insure against theft. This is a clause which looks to limit and reduce the risk of loss occurring as a result of theft. Arguable, this is a term that goes to risk as a whole. But also, it's arguable that it is a term that seeks to reduce the risk of loss occurring at the warehouse, i.e. of a particular place, of a particular kind, i.e. loss occurring by theft, and also at a particular time, i.e. loss occurring out of hours. Finally, just to flag the way Section 11.1 is drafted, we can't rule out that there are terms that might not define the risk as a whole, but also equally may not be caught by the Section 11.1 test. If that happens, the treatment of CPs and a breach under the old law might still apply. So just want to flag that before I hand over to Emma.
So Section 11, if it does apply, is looking at a situation where a breach potentially isn't relevant to a particular loss. So Sections 11.2 and 3 confirm that where a loss does occur and a particular term hasn't been complied with, the insurer can't rely on that breach to avoid or limit cover if, and if you look at the wording of section 11.3 on the screen here, the insured can satisfy that the non-compliance with that term could not have increased the risk of the loss which actually occurred in the circumstances in which it occurred. So notice that the burden's on the insured here to satisfy the test for section 11.3 to apply. Going back to Liam's example of the warehouse policy with the warranty to have 2 security guards on cover in place out of hours, it's pretty clear in those circumstances that the failure to comply with that term would have increased the risk of a theft occurring in the circumstances in which it occurred. Next slide, please, Liam. But it's important to note that the Law Commission's report made it clear that Section 11 isn't intended to introduce a causal element to look at what a particular term, whether a particular compliance with a particular term, would actually have prevented a particular specific loss from occurring. It's more about what compliance with that term would tend to achieve, and that is intended, based on what the Law Commission report said, to be more of an objective rather than a subjective test. So let's take the warehouse scenario example again for an example. What if the theft had occurred by the intruders entering through a back window of the property rather than through the front entrance where the security guards would usually be stood? Well, on the face of it, you might think that actually that the compliance with the term wouldn't have avoided that. But actually, because of the way in which the Law Commission intended this to work, Section 11, we think, means that breach of that term automatically suspends liability during the duration of the breach. Section 11.3 also introduces a grey area when it comes to looking at whether a particular breach is relevant to a specific loss. So if we take the warehouse scenario as an example for one more time, what if the loss occurred as a result of a fire rather than a break-in? Well, again, on the face of it, you might think that Section 11.3 would apply, but actually, what we're looking at here, what if the facts of the case are different? What if the fire arose as a result of an arson attack? Well, it might be that security guards would have noticed the intruders getting close to the property, and so they wouldn't have been able to get close enough to start the fire in the first place. Or at the very least, the security guards would have noticed the fire, called the emergency services, who would have arrived on scene and limited the amount of damage that was suffered. So you can see that Section 11 isn't as straightforward as it might seem. And there are situations where you might think that an insured could rely on Section 11.3, but actually there are much more nuanced facts about what actually occurred in the circumstances that might still allow insurers to avoid cover. We haven't seen any case law on the point yet, but we think it's probably only a matter of time before the courts do have to look at a dispute about whether Section 11 applies to a particular term, and if so, whether non-compliance with that term would tend to reduce the risk of the loss actually occurring. It'll be interesting to see how that plays out in practice. Now, I think that brings us to the end of today's talk. As Liam said at the start, we're happy to take any questions you've got, so we'll hand it over to you. If you haven't already done so, put any questions you do have in the question and answer box at the bottom of the screen.
Good morning. My name is Harriet Strevens, part of the insurance team, and I was going to pick up question and answers this morning. I'm pleased to say that the delivery of the topic this morning has been so successful, we have no questions and answers to provide unless somebody is going to come in late with a question. And perhaps, Liam, you'd like to leave it open for 30 seconds or so to see if any pop in.
Yes.
I think we can conclude that there are no questions. So over to you, Liam, in conclusion.
Thank you, Harriet. Well, thanks very much for joining us today. We will keep the line open for a couple of minutes if there are any questions. Thanks for joining, and please do connect with Emma and I. And if there's anything you want to talk about offline, we're happy to speak.
We have a question. We have a question.
Okay.
I'll just pass this on from an anonymous attendee. I would like to see further short workshops on those new to insurance, is one of the questions. I think we can bank that and understand the sentiment behind it. The second question is, thank you very much for your presentation. That's a nice way to end it.
Thank you very much. Okay, we'll end there. Thank you.